Okay, we're going to resume the hearing now. I want to begin by asking some additional clarifying questions about some of the things we talked about this morning, and then we'll give MetLife's representatives an opportunity to talk about what's happened commencing in 2010. But before we go there, earlier in the hearing, MetLife testified to its utilization of DeathMaster for annuities. And in the slide presentation earlier, there was some discussion that with an annuity, there's what's called a pay-in period and a payout period. And I'm wondering if you could describe for us what those two terms mean in the context of an annuity, if any of the witnesses could.
I'll be happy to take that question.
Great. If you could just get real close to the mic, I'm having the same problem. Thank you.
So as Mr. Cole's presentation outlined, a payout annuity is one where we are making payments to the owner in the form of monthly income. A deferred annuity is one which is in pay-in status, where the ultimate benefit to the contract holder is at some point in the future.
So you, in your original presentation or testimony, one of the witnesses used the phrase deferred annuity. That's synonymous with pay-in period for an annuity?
That's correct. In the trade, those are commonly called deferred variable annuities.
Okay. And with regard to annuities that are in a pay-in period, is there typically a death benefit associated with those annuities?
There typically is, yes.
And for MetLife's annuity product, do they typically have a death benefit associated with their specific annuity products that are in a pay-in or deferred status?
That's typically the case, yes.
And then you testified as well that DeathMaster was used initially manually and then more systematically with regard to annuities. Was DeathMaster also used for annuities that are in the pay-in period?
Yes, the description of the process that I outlined earlier that began in the early 2000s applied equally to our payout business as well as to a portion of our deferred business. And so let me just talk for a minute about that. So it was being used in the early 2000s, to the best of my knowledge, for across all of our payout business. For deferred annuities that were on some of our administrative systems that support the majority of our older, more mature blocks of business, we used it as well. And as I said earlier, as we continue to evolve those processes and procedures, this year we plan on continuing to expand that process to the rest of our deferred annuity business.
Prior to this year, what percentage of the deferred or pay-in annuity business were you using DeathMaster to do matches for?
I don't have the exact number, but I can tell you just at a high level that the majority of our in-force business, our book of business, blocks of business, are those older contracts. The newer business would be the ones that we plan on extending this process to this year. But I can get you the exact number if that would be helpful. Yeah,
that would be helpful. Because what I'm interested in is what percentage of the deferred annuities you were using DeathMaster for prior to 2010.
I don't have that with me, but we can get that for you.
As to those annuities that were in pay-in or deferred status, when in the utilization of DeathMaster you reached a match, what was then done with regard to any communication with the annuitant?
Sure. Again, we would use the same process on payout annuities and these pay-in contracts as well. And that process involved sending a notification or a death claim packet to the last address. We have a rigorous and periodic process for following up. If we don't hear back from that initial letter, we let that period goes on for a maximum of 5 years, again, consistent with the Internal Revenue Code's provision that allows a beneficiary to defer taking the death benefit for up to 5 years. If in the course of that 5 years we have still been unable to identify a beneficiary, we will go through what we call a finder process, basically using outside data sources to be able to identify a valid address. If at the end of the year we're unsuccessful there, then and commencing with the 5th year of that period from date of death, we will then begin our standard sheet process.
So that was the practice with regard to some portion of the deferred or pay-in annuities, but commencing in 2010, you've now expanded that practice to all of the deferred or pay-in annuities?
We will be expanding that to all of them this year.
Okay. And then I'm wondering if the term association group life has any meaning to you. And if so, what is that term generally understood to mean?
So, can you repeat the term?
I'm sorry. Association group life insurance?
I'm going to make an assumption that it would be group life offered through an association. I don't know of it as a formal term.
That's not a term we commonly use.
So in your testimony previously with regard to how you did or did not use Deathmaster for group life, were you including, if you will, group life policies for membership-based associations? Or is there any distinction in your business with regard to group life policies for association-based group life insurance policy?
For the purposes of, I'm not aware of any distinction.
And for the purposes of Deathmaster?
Death Index, no, I'm not aware of any distinction there. So if we have association business, it's very small. I mean, it's not a core market for us.
Do you treat that in any way different from the other group life insurance policies for which you have used or not used Deathmaster?
I'm not aware of any differences.
Okay. And then there was a document that was alluded to a little bit earlier in the hearing that provided a little more detail in response to some of our questions, and I don't know if that has been provided to us yet, but I'm wondering if you have it, if it could be provided to us, and if you'd be willing to tell us what the source of the document is, and then we can receive it and make sure it's a part of our record.
Commissioner, are you referring to the process for which we share information from individual annuities to other parts of the company?
It was whatever document was alluded to by counsel earlier, where there was some colloquy about the accurateness of the document, so that may be it. Okay.
Yeah. So what I can testify to is that the document that I have here, which we will share with you, is a true and accurate copy of the current version of this policy. This policy went into effect at the beginning of 2010. As I mentioned earlier, we had a less formal process that was in existence prior to that, before early 2010. The written description of the steps we take to share this information is what's reflected in this document. And if I could just read an excerpt from this document, I think it might be helpful in giving you a sense of the steps we take to share information beyond individual annuities.
Actually,
helpful?
It might be, but what I'd like to suggest is maybe, do you have copies for us? Maybe we can get a copy, and the court reporter can get a copy, and then we can take a look at it, and then if we have follow-up questions on it, we can ask those after the lunch break.
The copy that the witness has is annotations from counsel on it. We'll try to get you a clean copy over the lunch break.
Okay.
But the copy we have with us has communications on it.
All right. Well, then, why don't we wait to ask about that and wait to take testimony about it until such time as we can actually get a copy of it. Now, the other... The other question that I have has to do with MetLife's practices when you have a circumstance where a life insurance policy is not completely paid up, but some premium has been collected on that policy, and then for whatever reason the company stops getting premium on the policy. What does MetLife do in that circumstance with regard to a policy like that?
So it's going to be a varied answer because we have many different policy forms in different states and different what I'm going to call non-forfeiture elections that exist in those policy forms. So I can speak to a couple of examples, but more likely than not, it won't be a complete answer, and we can go through it, and you can follow up as much as you'd like.
Okay.
So the probably most important point I want to make in the context of those policies is if we did a death match subsequent to what I'm going to describe momentarily, that death match would include any active in-force policies, any policies in non-forfeiture status, and any canceled policies. So to the extent that a policy lapses for whatever reason, if later through a match we identify that that individual in fact died while that policy was in force, the policy value will be reinstated to the value that it was when the individual died, and the beneficiary would receive interest consistent with statutory requirements. So I just want to make sure that's clear first. So in some of our policies, they do have what are called non-forfeiture provisions. These non-forfeiture provisions are designed to keep policies in force in situations where an individual doesn't make required premium payments. In many cases, the policyholder can elect the non-forfeiture provision that they would like. For example, they might elect a paid in full, paid up status. They may elect extended term insurance. They may elect a premium loan. Essentially, if you think about policies that have cash value in force, depending on, and again, most policies have elections, we will honor what that election is. To the extent that that election results in the action that would happen, so in a paid up status, it would convert to paid up. An extended term, it would be extended for a period of time at a given face amount. And in automatic policy loan, the loan would be taken out of the policy proceeds. In all of those circumstances, the administration would be consistent with whatever the form would be required. That's what I believe, and we would act on it accordingly. So to your question, could there ever be a situation where an individual doesn't make a premium and there's cash value in that policy and the policy ultimately lapses? That certainly could happen. However, going back to my first point, if, however, we subsequent to that run a match and we find that that individual's death preceded the date that that policy lapsed, or whatever the value was at the time that that person died, that's the value that we use in the means of ultimately paying out to the beneficiary, or if we can't find the beneficiary, us cheating those funds to the state. So I gave you a lot there. I don't know if that's what you're looking for.
Could I just augment
Certainly.
Todd's answer with one other point? I think Todd testified earlier that on the industrial block, we had made the company had made a decision in the very early 80s, on or about 1981, to waive any future premiums under those policies, so that under that industrial block, no premiums are due. So the situation which I believe you're alluding to, we don't think can happen on the industrial block of business.
So with regard to non-industrial block business, what number of policies are we talking about here that MetLife has in the individual product line?
How many policies do we have in our non-industrial
Yes.
individual life block?
Yes.
Do you have that number, Andy?
Total in force, Commissioner?
Yes.
A little more than 6 million.
6 million. And in the early part of the 2000s, what number of policies in the individual block did you have in force that were non-industrial?
I don't have that number with me.
Okay, and in the 90s, does any of the witnesses know what, either in the 90s or early 2000s, what number of individual non-industrial policies were in force?
I don't know the answer to that.
Okay. With regard to the automatic policy loan provision that you just described a moment ago, if I understand that correctly, what that is a provision that allows MetLife to begin to collect from the cash value of the policy the premium that otherwise would have been required to be paid in the event that the policyholder is not paying premium anymore. Is that correct?
That's correct. As a means to keep the policy in force, in most cases, the individual is electing that piece, that making that election, such that their policy doesn't lapse.
And what, of the 6 million individual non-industrial policies that you have in force now, what percentage of those have automatic loan payment provisions?
I don't know.
Do any of the witnesses know what percentage of the book of business has those provisions?
I'm sorry, Commissioner, I don't know the answer.
Is it a majority of the book of business that has a provision?
I couldn't say, I don't know.
Okay, we would be interested in knowing more specifically what percentage of the in-force individual life insurance policies have the automatic loan payment provision. With regard to the utilization of Deathmaster as it relates to the individual policies, I believe it was your testimony that it wasn't until 2007 that there was a systematic utilization of Deathmaster across individual policies to determine if there is a match. Is that correct?
Absent any reference to litigation, which we wouldn't speak to today, that is correct.
Okay, so let's talk about litigation, because you've caveated your answers a couple times by qualifying and saying that
correct.
Absent litigation, we did X, or absent litigation, we did Y. Can you share with us how Deathmaster has been used in the context of whatever litigation is that you're referring to?
I don't think I can.
Let me just offer as a general statement, we're glad to provide the details of that in a confidential setting. For purposes of this setting, I'll just note that for purposes of complying with obligations under certain settlement agreements, we made very narrow and limited use of the Deathmaster file, and happy to share the details of that in a more confidential setting.
Can any of the witnesses testify at this point whether that was litigation brought by a state regulator?
It was not.
And are all of those matters resolved at this time?
They are.
Is there any pending litigation involving the utilization of Deathmaster?
There's not.
And with
And the
regard,
subject of those litigations was not utilization or non-utilization of Deathmaster.
but Deathmaster was used in some context in association with the
resolution.
the resolution of those particular lawsuits.
Yes.
Okay. And have there been settlements that have been filed publicly with courts with regard to those lawsuits?
Yes.
And so if the settlements are publicly available, why is it the witness can't testify about the utilization of Deathmaster in association with those lawsuits?
I'm glad to provide you with copies of the settlement agreements, glad to provide you the details of how we executed our responsibilities under those settlement agreements in a more confidential setting.
So the settlements themselves are public, but you can't testify about them at this time?
The witnesses are not prepared to testify about the details of how we executed our obligations under those settlement agreements. The execution of obligation under the settlement agreements in some instances included use of the Deathmaster file to make sure we had fulfilled our obligations under those settlement agreements.
Okay, so we're not going to waive here our right in a public hearing to have access to the settlement agreements and testimony related thereto. I know you're asserting that they're confidential in nature and you only provide them to us confidentially. I respectfully disagree. I think if the settlements are public, we should have a right to them. And I think our subpoena contemplated all utilization of Deathmaster, so I don't think it's responsive also not to have a witness that can testify about them.
And just to be clear, that we are quite happy to provide you with copies of the settlement agreements themselves, and have no concerns about discussing the settlement agreements with you.
Okay, so we're going to reserve our ability to call witnesses back from MetLife to talk about those settlement agreements once you've produced them for us.
We'd be happy to do that.
All right. Is there any other, other than your utilization of Deathmaster commencing in 2010, are there any other uses to which Deathmaster was put other than what you've already testified to so far in this hearing?
I believe we've given you a comprehensive view for our whole business. I can't tell you definitively we've covered, the four corners of the organization. As I explained before, it's a very large organization, but to the best of my knowledge, I think we've covered the gamut. Actually, I'll make one point. We mentioned retained asset accounts, but I don't believe we talked about them. So, we certainly can and will if you'd like us to, but.
Okay, I think what we're going to do is we're going to wait till later in the hearing to pick up the issue of retained asset accounts.
Okay, but that is another area. So, to answer your question, I believe we've covered the gamut. I can't be sure of that, but certainly we can go through in as much depth as you'd like, any specific area.
Commissioner, could I just clarify one other point when you had asked about non-forfeiture options? I just wanted to be clear that you understood that when we did the 2007 match against the Death Master file, we considered that situations in how we thought about the logic for that match. And that match included a match not only against enforced policies, but also any policies that may have been canceled in the example that you gave. So that we believe, to the extent that that may have happened at some point in the past, since that 2007 sweep was in fact an issue-to-date type sweep, we believe any such situation like that would have been caught by that match. So can I say we got everyone, but we think we were concerned about that situation. We contemplated it, and in the logic that we developed, we intended to uncover all of those.
How far back in time did that sweep go with regard to life insurance policies issued by MetLife?
It used the entire Social Security Death Master file. So on the one side, from the Social Security data, all of the Social Security data was included, and from our side, as we've testified before on the individual business, we attempted to include the vast majority of the business, other than those assumed blocks, and policies for which we had a Social Security number.
I understand that, but you've testified that not only did you run the sweep against enforced policies, but also policies that had lapsed, I think is your testimony. And so my question is, how far back in time did you do that run to try to pick up lapsed policies?
I think we went back as far as we actually had data on administrative systems. The earliest death that we identified in that particular match was, I believe, in the late 1970s. We actually picked up a death that was earlier, in the early 1960s. It appears that that was on a policy owner, not on an insured, however.
Okay, and you've testified earlier, too, that originally Death Master was used manually with regard to group life insurance policies in a manual fashion, and then later on there was...
Not group life, Commissioner.
I'm sorry, say again.
You said group life, not group life. You may have meant group annuity.
I meant group annuity. You're right. You're absolutely correct. I need to have a better understanding of the computer records that MetLife has with regard to life insurance policies. At what portion in MetLife's history did it begin to actually computerize records with regard to life insurance policies?
So that's a difficult question to answer. You know, the enhancements to technology that have emerged over the last 50 years are constant. So I'm not in a position today to testify to all the different enhancements that have happened, and I'm not aware, frankly, of what happened when, and I don't think any of the other witnesses are. What we can do, and we'd be happy to, is follow up in writing with some information that kind of lays out what happened specifically when, but I think you're asking for things that happened back in the 70s, 80s, and 90s, and it's very hard to put all that together in the level of depth and accuracy that I think you'd want for this discussion.
Are records associated with all of your in-force life insurance policies computerized now?
I want to be careful to say all, but I believe the vast majority of them are. If I say all, we'll find one that isn't, but I believe for the vast majority they are.
And at what point in the company's history would the company be confident in saying most, if not all, of the records were computerized?
I think you're asking me to speculate on something I don't know the answer to. So I don't.
Any of the other witnesses know at what point, with some confidence, MetLife felt that it had all of its policyholders' records computerized at some level?
I don't think I could. And now
I think the battery may have
I
died.
think the battery may have died.
Okay, can we have somebody help with that microphone? And maybe you can borrow the microphone to your right. Thanks.
That's working now.
Thank you.
Sorry. I can't speculate as to when that would happen, but I could give an example. Prior to our demutualization, the company took a very specific, undertook a specific effort to try to find all of its, to make sure that it had records on all of its policyholders. And so there were techniques to use, including address verification associated with that demutualization in 2000, 2001 to attempt to find each and every policyholder.
Okay, so prior to that period of time, though, you've indicated, actually, let me back up. You've indicated with regard to the industrial policies that only some portion of those industrial life policies have Social Security numbers associated with them.
That's correct.
And I think you said there were roughly 1 million or so industrial life policies.
There are 1.5 million.
1.5 million, I apologize. And I think you indicated that it was something on the order of 800,000 for which you ran Deathmaster against because you had a Social Security number associated with those policies. Was that the right number?
No, I think, well, you probably have yeah. I think it's about 800,000 that do not have.
It's actually it's a little bit higher than that. It's closer to it's more approximately 1 million where we don't have the Social Security numbers on the industrials.
Okay, and then are all of the industrials computerized at this point?
To the best of my knowledge and belief, they are.
Were they all computerized as of 2007 when you ran the Deathmaster sweep against individual life insurance policies for which you had Social Security numbers?
I believe that to be the case, Commissioner, but I can't say that with 100% certainty.
Was any effort made with regard to the industrial life insurance policies for which you did not have a Social Security number to run the other elements of Deathmaster against those policies to determine if there might be a match?
We actually did get data when we did the 2007 match, and we looked at what we called other than the 3-point matches, and it was our experience. We found 39,000 what I would call other than 3-point matches when we did that 2007 search. We diligently, through including human research, the match was just the starting point. We actually researched all of those, and it proved to be a very unreliable use of the Deathmaster. We only uncovered approximately 700 valid claims payable to beneficiaries out of the 39,000 where we had other than a 3-point match in that 2007 sweep.
So with regard to the 39,000 that you found there was a match other than a 3-point match, what steps did you take to try to contact those policyholders or their beneficiaries?
I think that the match was the first step. We used internet third-party vendors, for example, to help us, like RootsWeb or Accurant, to try to find the individuals, and other record searches to try to find them.
So was it then after those additional record searches that you narrowed the number down to 700?
That's all that we could find.
Okay.
I think it's also important to clarify that this may be an issue if we couldn't find them, or it also may be an issue that it's just a mismatch, that you have somebody on the file. So a very common example is in the industrial block, you have an individual policy owner who's the owner, but the insured is their child. And the record keeping way back when that was set up wasn't particularly great. So our goal was really were claims where we have a valid liability, and if we do, then act on them. And the problem was, absent a 3-point match, Social Security number, date of birth within 2 years, and name, the effectiveness was far lower than it would be.
Yeah, it was a case that it was not our insured.
Right.
With regard to the industrial policies, was it the practice of MetLife to have a physical policy file for each of the industrial policies?
I'm assuming you're asking back, way back when?
Yes.
I don't know the answer for that. I think it's a reasonable assumption that we had some type of record, but I can't testify that for sure.
When the Deathmaster sweep was done of the individual life insurance policies in 2007, were there written physical records associated with the industrial life insurance policies in force at that point?
I I don't, well, there may have been, but if your question is, what data, I think did we use to match? Is that what you'd like? Because or did we use paper files?
That's where I was going to go next.
Yeah, I don't believe we did. I think what we did was we took the data that we had from our admin systems, created a file, and then used that file to do the match. What we didn't have on that file were the individuals that did not have Social Security numbers, which is a fairly substantive portion of the industrial life block. I should make a point on that block. Keep in mind, in the 10 years of late 80s to early 90s, we put forth substantive efforts to find those people, whether it was through our family reunion program, national advertising, national spokesman. We had Willard Scott, be our spokesman. And then prior to demutualization, another exhaustive effort to find those people and see if our addresses were right. So the SS tool we didn't find to be as effective as others for individuals where we just didn't have the SS.
I have several newspaper articles from that time which were explaining our efforts to find industrial policyholders. And in fact, during that period, that multi-year period where we did the family reunion program, we spent about, the records show, we spent about $20 million in terms of TV advertising, print advertising, events such as luncheons. So we had a particularly intense effort in southern Florida where we believe that many of the policyholders coming from the Northeast, where a significant portion of our business was, may have relocated. We hired Willard Scott, who was a TV personality at the time, to actually host many of those. And in Florida, at Disney World, we actually had a pavilion set up so that visitors could come over and query the systems to find out whether or not we had an industrial policy for them.
How long was the family reunion project in effect?
From the records that we show, up to 10 years.
What was the period of time we're talking about?
I believe the dates of these articles are in, this one is October 25th, 1990. So it started in the late 80s. It ran through the mid-90s. And in some cases, what the contact actually was, put us in contact with the policyholder so that the address records and the update could be made. But there was no death at that point in time. So one could argue that the program's still in force today because we are still getting claims from individuals who were reunited with the company through the family reunion program.
How many policyholders were identified through the family reunion program?
From the records we have from that time, we estimate about 500,000 policyholders were reunited with the company through the family reunion program.
And at the time that you did the 2007 Death Master sweep, was there any manual check of the industrial life insurance policies against the Death Master database?
If, in fact, we had a Social Security number for those policyholders, we may have updated it over time, then they would have been run, they should have been run against the death index. If we didn't have Social Security number, we did not have a separate match process for those policies where no Social Security number existed.
But even as to those that you had Social Security numbers, my understanding is you're doing a computerized match based on Death Master file running against your administrative systems. My question is slightly different, and that is, was there any physical search of the industrial policies, physical written records at the time of the 2007 sweep to ascertain whether there was information in the physical file that might match up with Death Master?
I don't believe so, but I just want to clarify, if there were records, physical records for the block, our intent would have been to have captured those in our systemic records, I believe. So my instincts would be if we had records of information that were at one point in paper, we would have looked to have had that into our systems.
I understand, but there was no physical inspection of written records.
Not that I'm aware of.
Okay. And then you've testified earlier that your utilization of Death Master was limited to a 3-point match, as you've described it. Social Security number, date of birth, and name.
We should clarify that.
Please.
So we We matched, of the files we matched with a 3-point match, we found 28,000 matches. That wound up in about 18,000 claims. 28,000 matches, about 18,000 claims, with a 3-point match. We also matched with just Social Security and name, just Social Security and date of birth. And I'll ask my team to confirm. I assume just Social Security alone, too. That resulted in an additional 39,000 matches or less than complete matches. Of that group, we found about 700 good claims.
When you say good claims, does that mean that someone actually made a claim that fell within that 39,000?
No, we found that those were legitimate deaths for the individuals who were on our administrative record. We would have invited the beneficiary to submit a claim, and if in fact the beneficiary couldn't be reached, those claims then would have gone through our unclaimed property system.
So with regard to inviting those beneficiaries to make a claim, those that fell within the 37 or 39,000?
About 39,000.
39,000. Did you invite the beneficiary to make a claim only after you subjected those 39,000 policies to the additional data searches that were testified to a moment ago with some of the other data sources?
I don't know exactly the sequence of it, but I'll try to speak in generalities.
Okay.
We identified 39,000 matches, and I would say for the same part, 28,000 3-point matches. So 28,000 3 points, 39 1 or 2-point matches, all with SS. All of those were investigated. And the effort to investigate them involved first determining, I think it would be first determining, is this truly a match? And then once we know it truly is a match, can we find the beneficiary? And if we can't find the beneficiary, and in fact we have validated that it is a good claim, going ahead and proceeding with unclaimed property procedures.
So there was some effort to try to find some location for the beneficiary after you determined that there was either within the context of the 28,000 for which you had a 3-point match and the 39,000 for which you had a 1-point or more match. You then made an effort to see if you could find where those beneficiaries were by looking at what precisely?
Well, on many of them, once we determined it was a good claim, we would have had a beneficiary on record, and so we would have written to the last address of the beneficiary on record. If, in fact, the last beneficiary on record couldn't be found, we would use other sources in an effort to find that beneficiary, including some of the computer sources that we've talked about. And if that couldn't be done, begin the unclaimed property process.
And then what did the communication you sent to the beneficiary's last known address or other addresses provide? What did it state to the potential beneficiary?
I do not know. Do you guys know?
And that's a level of detail.
Did you require them to submit a claim?
We would have invited them to submit a claim, yes. Yeah.
Okay. And then was there any effort?
Just to be clear, because
Yeah.
I believe that's what we did. I don't want to testify to the record that that's exactly what we did, so we can certainly follow up with you on that.
Okay, that would be helpful. Was there any effort to publish the names of the individuals for which there had been a 3-point match and the individuals for which there had been at least a 1-point match?
So, is there any effort to publish the names?
But let me define what that means.
Okay.
I mean, somehow, in some way, make those names publicly available.
So, let's be clear about what we're talking about, because there's different cohorts. There's the 28,000 and 39,000 that had an initial match that kind of came up that could be a match. Then the 18,000 and the 700 that actually were a match. Which one would you want me to respond?
Let's start with the 28,000.
Okay, so the 28,000 and the 39,000. You know what? I'm going to apologize. I've got a phone in my pocket. No, it wasn't mine. Okay. So the 28,000 and the 39,000, before they were brought down to the 18 and 700, were just data that showed we could have a match. So until we took the 28,000 down to the 18 and said we really do have a match, and the 39 to the 700 and said we really do have a match, there wouldn't have been any outreach action to do because we didn't have. My example could be that we identified that the person who died was not the person who had coverage, and that happens fairly often because of data inconsistencies. So
just to make that clear, the policy owner may have died, but not the insured.
So if that's the case, there wouldn't be a liability to be paid.
So, but with regard to the 18,000 that I guess are derivative of the 28,000, that was 18,000 claims were actually made of the 28,000?
So 18,000 individuals of the 28 where we felt we had an accurate match. It was really a match. And those are the people that we began the claim investigation notification program. Those are the people that identified that ultimately resulted in $80 million in payments, of which 50 million or so were actually paid to beneficiaries, and another 31 million were put into our unclaimed property system for escheat.
So was there any publication of the 18,000 names?
So on the ones where we were able to find
Yes.
the Benny, no, because I would think not, because we found the Benny and we paid them. So
Well,
on the balance,
Actually, I thought you said that you did a 3-point match, discovered 28,000. You did a further analysis and decided 18,000 of them were actually accurate. And
Right.
then there was a subset of that where actual claims were paid.
so
It was about 3,000 or so, I think you testified to
No,
earlier.
no.
What was
Let me clarify. We're gonna just do the 3-point match first, then we'll come back to
Right.
the 2-point match. So think of it this way: about 28,000 matches, of which 18,000 were accurate matches, where we determined it was a true match. We truly had a liability.
Meaning it was our insured.
It was our insured, right? It was our insured. I should be clear about that. May not have a liability, but it's our insured. With those, then we wrote to the beneficiaries and we said, look, we have reason to believe, and I don't know if this is exactly what the letter said, but this is the gist of it, that so-and-so died and they had insurance. And as a result of that, we paid out $50 million in claim payments.
How many policies?
So I'm going to try to see, I don't know if I can be linear on this. So 18,000 policies, of which 50 million were paid to Benny's in dollars, and 30 million.
No, I got that before.
Yeah,
How many policies?
I don't have the, we certainly can get that. I don't know if you have that.
I don't have that. I don't have the number of policy. I have the dollars.
But not all 18,000 were paid out, I take it.
They were either paid out or they were put into our unclaimed fund system to be escheated.
Okay, so with regard to the 18,000, either they were paid out or they were escheated.
And again, I want to be careful in saying all, but generally speaking, that's what should have happened.
Okay, then with regard to the 39,000 for which you had a one or more match, only 700 were either paid out or escheated.
You got it,
Okay.
approximately.
But with regard to the original 28,000 for which you had a 3-point match and the 39,000 for which you had a 1 or more point match, there was no publication of the names of those individuals. You've described what you did with them, but there was no publication of the names of those individuals.
Correct. That
was my original question.
Yeah, so at some point, some segments of them, as they funneled through the
understand.
system, may have resulted in some states which require some level of publication prior to funds being escheated. We would have executed our responsibilities to do that. But so I'll give you an example. In one state, they may say, before you escheat, this isn't the way California does. In California does an outreach. In some other states, they may require us to do an outreach. And if we were required to do that in a given state, we would have done that. But to the segment between the 28 and the 18, or the 39,000 and the 700, there was no outreach because we didn't identify those as lost policies.
Okay. At the close of the last section, there was some testimony about what the company started to do in 2010 with regard to the utilization of Deathmaster. Why don't you go ahead and share that with us now?
Sure. So And I want to combine that
I'm
with-
sorry, Mr. Katz, I apologize. Ms. Miller has a follow-up question.
Of the $31 million that was put into your unclaimed funds system in 2007, all of that was related to California claims has been escheated, right?
So I can't testify to that.
Well, because their statute is 3 years. I know in Florida it's 5, and we talked about that at our hearing, but
So my understanding is that in California, there is a 3-year period, and in the report for 2011, which ultimately would be escheated at the latter part of 2011, you would see an increase in the amount because of this group. So, and we can certainly testify to those amounts if you'd like.
So I think the controller is going to have a line of questioning
Okay,
about
so you want us to
sheetman
wait?
responsibilities under California law.
Okay.
But, so if we can hold off on that one for the moment, Ms. Miller. Let me ask, though, if there aren't any follow-up on this line of questioning, if we can now go to what the company started doing in 2010.
Sure. So I think I want to back up just a second to get to what led to what we did in 2010. So in 2007, we ran this match, and we learned a whole lot of information. We learned about 3-point matches. We learned about 2-point matches. We learned about processes to connect with policyholders. In fact, some of that learning goes a little bit even further back. And throughout 2008 and 2009, we were going through these exhaustive procedures as best we could to locate these policyholders and pay out these beneficiaries. And I kind of gave you a sense of the order of magnitude. In 2009, we had some structural changes in the company, and this may get at Commissioner Chung's question about kind of decision-making. We created a U.S. business at that time. So prior to that, business units were managed separately, and we created one U.S. business at that point in time. And throughout, I'd say, the early part of 2010, we began looking at the experiences that emerged out of the 07 match. We also were engaged in discussions with regulators about questions around unclaimed property. And ultimately, we took a look at what we wanted to do across our U.S. business in this specific area. And I was charged to lead a team to look at this issue holistically. Based on that review, determined that we felt we had an opportunity to use Death Master Index more effectively across the U.S. business to provide the safety net that I've been describing before, presented a recommendation to my boss to use that universally in a way that we'll describe, and I want to be careful, universally, generally for the majority of our business. We'll describe in depth in a moment. That recommendation was accepted, and in late 2010, we began the process of executing on that program. So I can certainly now tell you about that program, or I can pause and allow you to ask any questions around anything I shared.
Why don't you go ahead and talk about the program?
Sure. All right, I'm going to turn it over to Mr. Cassandra to do that.
So in recognizing the fact that the Social Security Death Master file could be a very effective safety net, we took the decision to match against the Social Security Death Master no less frequently than annually the policies for which we had records. Okay, so that includes our retained asset accounts, our individual life insurance businesses, our annuities, and the group life insurance business where we have the records and are the record keeper. We believe that an annual match will provide a very effective safety net. We believe those procedures were recommended to include, as we did in 2007, logic to capture not only active policies but also any policies that may have ended due to expiry of the non-forfeiture option period. So in late 2010, we began our first match consistent with this new policy by matching our retained asset accounts. And we have been moving through, and in fact, the individual business has been matched again, or will be completely matched again to the extent that we have the records by the end of this month.
Okay, so between 2007 and 2010, were there any sweeps of product lines using Deathmaster?
Absolutely. I mean,
Which ones?
So we've testified a little bit to what we do in annuities and disability and long-term care, and so those processes that we testified to already were going on during those durations. Certainly for.
And Commissioner, I would add on the individual annuity side, as I testified earlier, we have a regular.
Can you hold up the mic a little bit closer, sir? I'm sorry.
Sure.
Yeah.
In the individual annuity business, we conduct sweeps on a monthly basis for a payout business and on a quarterly basis for a deferred pay-in business.
Okay, so on the annuity side, between 2007 and 2010, you're doing monthly for payout annuities and quarterly for pay-in annuities.
As I said, we began that process in 2000. The only caveat I would add is that on the sweeps we're doing on our deferred book of business, our pay-in was limited to our older blocks of business.
Okay, and then you have testified earlier about what you did with regard to corporate-owned and group life insurance, disability, long-term care. That work continued between 2007 and 2010, I take it.
I believe it did. I mean, we want to get you, certainly it asked for the dates when we commenced long-term care and disability. I believe those preceded 2007. We will certainly verify that and get you that information.
Okay, so on the group life insurance side, are you doing, during this period of time, 2007 to 2010, are you doing quarterly, monthly, or annual sweeps of Deathmaster, using Deathmaster?
We were not doing sweeps of group life insurance.
Okay. With regard to disability...
Except, I'm sorry, again, for completeness, except in those situations which I testified to where specific customers may have done that on their own.
Okay. And then with regard to disability insurance, 2007 to 2010, monthly, quarterly, or annually, do you know?
Yeah, I believe it was monthly.
And then with regard to long-term care insurance from 2007 to 2010, monthly, quarterly, or annually?
I believe it was monthly as well.
Okay. And so, let me ask the same question with regard to company-owned life insurance, period 2007 to 2010. Were you using Deathmaster monthly, quarterly, or annually?
Yes, I believe it was monthly. And so you may be asking, why are the frequencies?
You saw where I was going.
Well, the frequencies, part of the frequencies.
Well, more specifically, let me just ask the question,
Go ahead.
so you have the question. Why are you using it on a monthly basis for these other product lines, but only annually with regard to the individual life insurance product line?
Right. So we believe that the frequency needs to consider the underlying contractual provisions and the promises that are embedded in those policies. So on the annuity business, for example, the main use of the Deathmaster file is to avoid durational payout errors and to avoid having, to try to go out and recover payments that were made after the death of the annuitant. Again, under the contract, the annuitant must be alive in order to receive benefits. So again, we use the Deathmaster file to avoid errors in that situation. On the life insurance side, as we've said, the process for beneficiaries presenting a claim to the company works exceedingly well and has been the historical method for individuals to claim life insurance benefits. And based on the experience of our 2007 study, we saw that process did in fact work exceptionally well. While we uncovered in that 2007, we uncovered about a little over $80 million worth of benefit payments. That was just a small fraction of the total benefits that were incurred, claimed, and paid out using the normal process. So while $80 million, it's a meaningful number, certainly, it did represent a very small percentage of the total benefits that the company paid. Now, again, we think that the Deathmaster file's best use in life insurance is as a safety net under that standard process. One of the concerns you'd have is that individuals will certainly, based on their own facts and circumstances, want to take a little bit of time to get their loved one's affairs in order before they actually make a claim for life insurance benefits. And if you're making, if the company is matching almost in real time, the company would be injecting themselves into that process, perhaps inappropriately. So what we think is the standard process of beneficiaries claiming their benefits works very well. An annual match will serve as a very effective safety net. And the last point I would make is that in most, under the provisions of most states, interest is payable to beneficiaries if claims are delayed. So in fact, in California, it's my understanding that delayed settlement interest is payable to beneficiaries from 30 days after the date of death. So, the fact that the match is not done on the same frequency, there's actually good underlying reasons for a more staggered match on life insurance than on annuities.
So I have to say that, again, the 1% figure is a figure of paid claims. I'm not persuaded that represents the percentage of total policies in effect or policies that have elapsed due to death where someone has died and a benefit is owed. But even taking your 1% figure for the moment, which is $80 million, that's a big number. How many policyholders does that represent? Because these are relatively low-value policies, it's my understanding.
I think the answer to that was the result of the 18,000 and the 700 that we talked about before.
And,
Okay,
and that's
so-
going back over a really long time. And so about 18,000 or so policyholders going back, 20, 30, 40 years. So it's the vast majority of policies are coming in through the normal process.
Well, the vast majority of claims that you pay are coming in through the normal process. That, to me, still doesn't answer the question as to whether or what percentage of claims that should be paid or benefits that should be paid because someone died and there was a policy in effect, what percentage of your total policyholders that represents. And so without belaboring that, I'm not persuaded of the argument you're making with regard to the frequency of utilization of Deathmaster in the individual life insurance context.
But I think I wanted to just take a minute, if you'll indulge me, just to make sure you understand that when we did when you do that Deathmaster file sweep, it is in effect an issue-to-date sweep. So any individual who had passed and Social Security number is on the Deathmaster file and it matched with our records, we were able to identify those folks and actually pay out the benefits to their beneficiaries. So I think to the point of, is that a good estimate of individuals who may not have otherwise claimed the benefit? We think that it is because it is, once you do that match, once you do the match of the Deathmaster file and you go back through the whole history, you essentially have swept it clean up to the point, to the extent possible. Your intent is to sweep it clean up to that moment in time.
So there are two cohorts, Commissioner, which I think is you may be getting at, which is important, that aren't included in those numbers, and Mr. Hansen got at that too. One is the individuals who are not on the death index, so that we can't match against them, and two, the individuals who we don't have Social Security numbers for. So that's the place that I would say supplements the 1%, if that's where your line is going.
Well, what you've testified to is that before you get to the Deathmaster sweep in 2010, you assume that all of the records of your policyholders have been put in your system, but you can't tell us when that happened and how much that has happened. But that's one big assumption. Second, you have to have a match, at least initially, of at least 3 points, and then sometimes 1 point. So, and again, I'm not convinced that the 1% figure is actually representative of the total percentage of policies in effect or policies that have lapsed for which a benefit should be paid. But I don't mean to belabor the argument on that point. I guess there were a couple of examples that the slide presentation went through that I want to run by you and see if I can get your reaction to. So I have a better understanding, we as a panel have a better understanding of what your general practices are. One example was a circumstance in which there's some communication from the relative of a MetLife policyholder in which that relative of MetLife policyholder says, look, the policyholder has died, what is it we're supposed to do? What does MetLife do in that circumstance when they receive that kind of communication from the relative of a policyholder?
So I'm going to answer the question relative to our individual life business, if that's okay, because I think we can give you a dozen different answers. Is that really where you'd like us to focus in? I think that's where the example was.
I'm sorry, start with the individual life.
Yeah, that's where I think the
Product line,
example
yeah.
came from.
Okay.
So we do get some of our claims through telephone calls from beneficiaries or even other family members. And when we do get that the call in that says the person died, that would kick off our claim process. We would then send the individual information, asking them to fill out claim information and provide us with proof of death. And we would, if we received that information back, we would then proceed with paying the claim. Now, the follow-up tends to be, well, what if you don't get it back? Well, what do you do next? Well, we have procedures, and I don't want to attest to them exactly, but they involve at least 2 or 3 outreaches to who we deem to be the beneficiary to really determine, do we have a valid claim here? All we have so far is somebody called us and told us that someone is dead. We make best efforts, if in fact we can't get notification, to use third-party sources to verify whether we have a valid claim here. And in some cases, we'll write to the state in an effort to get a death certificate, all in the effort to assess whether we have a valid claim here. If in fact those efforts prove to be insufficient, or they prove that there is no valid claim, we then end the process. We have not taken on, we don't have a liability, we don't have funds due and owed, because all we have is a call from someone that told us that someone was dead. If, however, through that process we do get the information to secure that there is a valid claim and proof of death, and we have a liability that's due and payable, we will then search out a beneficiary and see if there is a beneficiary to be paid. If there is a beneficiary to be paid, that beneficiary would be paid through the normal process. If, in fact, the beneficiary can't be located and we go through a process of searching out that beneficiary and ultimately deem them, can't find them, then we'll go through our unclaimed funds process.
And so in all of these responses to that sort of communication from the relative of a policyholder, do you require a death certificate as proof of death?
So, yeah, our general procedure, and we do have some exceptions, which I can certainly talk to. On 9/11, we didn't require death certificates. At the Massey Energy thing, we didn't require death certificates. So there'll be exceptions. But our normal procedure is when someone reaches out to us, tells us that someone's dead, we will ask them then to complete paperwork and provide us with information that shows there's proof of death, which is a death certificate. And that, once there is proof of death and we have a good claim, then we can proceed as I described.
And that's true even when you have a 3-point death master match for that individual?
So good point. I should have used the other example. So we did make a decision when we ran the 2007 match to proceed without death certificates in an effort to expedite those claims. Am I getting that right? For the vast majority?
For the ones that we entered into the unclaimed property system.
So
Just to be clear, for escheatment purposes, obviously we couldn't pay, right, there was no Benny. If there was a Benny, we would have gotten the materials.
So let me,
If there
could you
was no-
repeat
yeah.
that?
She didn't hear my answer, so I repeat it. For escheatment purposes, okay?
So make sure I understand then, with regard to the utilization of death master and the two universes, the 28,000 and the 39,000, you suspended your normal requirement that you have a death certificate to pay out beneficiaries in that context using the 2007 sweep, but you did require a death certificate for purposes of escheatment. Do I understand that correctly? You want to explain it again? Okay.
No, I'm sorry, Commissioner, I think you had it backwards on that one. So if in the 2007 sweep, after the match, outreach to beneficiary, invited a claim, would have gotten the death certificate and paid to the beneficiary. For those individuals where we couldn't find a beneficiary, and we entered those benefits into our unclaimed fund system without a death certificate.
Okay, I understand. So required a death certificate to pay out the benefit, but to enter them into the unclaimed property system for purposes of escheatment, you suspended the death certificate requirement.
That's correct.
As it relates to that sweep.
Yes, I believe that's
Okay.
correct.
Is that similar approach being utilized in 2010 going forward under your new policy?
I don't know that we've actually come to take that decision as of yet.
Okay. And then the other example in the slide was a situation where mail is returned to you when you've sent it out to a policyholder's address, and you know from the mail being returned as well as a death master match that it would appear that the individual has died. What does the company do in that circumstance?
So again, you would like me to answer in reference to the individual life business, Mr. Commissioner?
Yes.
Okay. So the death match we've already described. So whether or not there was a return mail issue wouldn't change or alter the way the Death Master Index program would have worked. We still would have followed and proceeded as I described. If you're asking during the normal course of business, we get return mail from a policyholder, we would make efforts to try to get the correct address for that policyholder as best we could. Now, we're probably here talking about policyholders that are in paid-up status, because if they're not in paid-up status, they'd be paying us. And that was sort of the genesis of some of the things that I described with the family reunion program, of really trying to reach back out and find those policyholders. But just because a policyholder is lost and we're not connecting to them doesn't mean that they're dead. I don't know if that's where you're going.
Are there any circumstances under your new policy, which you've begun to implement since 2010, are there any circumstances under which you would get some indication that the policyholder may have died, whether it's a returned letter, a phone call, and then you run Death Master against that individual to further confirm whether the individual has died?
Yeah, so even going back and prospectively, I talked about when we get a notification that an individual has died, a call or so forth, we will exhaust many means, and in some situations we'll check death index. What we're really...
I apologize. Let me clarify the question. If a letter comes back to you or some communication, some written communication that you've mailed to a policyholder comes back to you, do you take any steps at that point to ascertain whether the individual is alive or not?
So I'm trying to presume what the situation is. Let's say it's a bill. Is that because that would be the...
Fair enough.
Yeah, so if we send someone a bill and they don't respond, we'll try to find that there's a good address. I don't believe in the life business we're using mail as an indication to say, okay, now this is the moment where we should go and check death index. However, when we ultimately sweep, okay, and if that person had died, we would then find out about that person.
But it's not until you do that annual sweep that would occur.
Yeah, I think, and I just getting at your question, when we get return mail, do we then say, that may be an indication that this person is dead because they're returning mail, let's go find out? I think that's the gist of what your question is. Okay. I don't believe we do that. I'd prefer to reserve, maybe at the lunch break, I can check with our experts and just make sure I articulate that exactly right for you.
Okay. And are there any other circumstances under which you would run Death Master against the name of a policyholder prior to the annual sweep that your 2010 and going forward policy contemplates?
Yeah, so as I described, when we get a notification of death, someone calls us, and we write out to that person and say, hey, complete a claim, and that individual does not respond, and we send a second notice and we send a third notice, and that person still doesn't respond, we will bring other efforts to look at publicly available data, including, depending on the circumstance, death index, to see if, in fact, we can get a death certificate, validate whether or not there is a claim, and if there is one, then reach out to, in that case, probably by then those funds are going to be escheated because probably we've exhausted best efforts through the person, but
You used the term death index. Is that different from Death Master?
same concept.
Okay.
But the nuance that I want to make sure is one thing that we've talked about is a systematic run against all of our policies. And now what I'm talking about is using it as a tool periodically when we've been notified as a death to check a file and assess whether or not that individual's on the file. It's not a run. That wouldn't be a...
I understand. But in addition to receiving a letter or call from a relative, are there any other circumstances where you would use Death Master to check to see whether, other than your annual sweep, to check to see whether an individual policyholder has died?
So let me broaden it to say some other form of notice, because it could be a call, it could be some other way. And in those cases, I think we'd proceed as I described. Absent some other form of notice, I'm not aware of using Death Master, but again, I'd reserve the right to just make sure I get you a complete answer there.
Okay. So we're going to, in a moment, break for lunch. Let me see if any of the other members of the panel have any questions to follow up before we do that. Ms. Miller?
When you have a bad address and you look for a new one, do you use Accurant or a service like that to look for a new address?
So we run our admin files against the National Change of Address database, I believe, quarterly. When we have a bad address, we have an address correction unit. I'm not sure exactly what the tools are that they use, but we can certainly follow up and tell you what they are, but their goal is to try to find the address. I don't know if anybody else has stuff.
Any other follow-up from members of the panel? Mr. Hanson?
For group and individual annuities, what percentage are in the accumulation or deferred period, and what are in the annuitization period? Any idea?
Unfortunately for group, I don't know the answer. For group, and Frank, you can help me most.
Yeah, for group annuities, the vast majority are actually in payout status or are in a deferred status pending. If you think about the way the group annuity business works, an individual might have left an employer with a vested benefit, but they can't begin to collect on their retirement annuity until they reach a certain age. So we have both types, but the vast majority are actually in payout status, receiving a monthly benefit on the group insurance, the group annuity side.
You know, in the individual annuity business, I don't have the number with me. We can get that if you'd like it. But I believe that the vast majority of our cases are not in payout. A much larger portion of our business is represented by deferred or pay-in annuities.
Do you distinguish between older books of business, and that's where you run Death Master against them? What distinguishes an older book from, where's the delineation?
An older book of business is business that we typically wrote before, I would say, generally speaking, 2000, 2001. Those are contracts where the contract holder is likely to be older in age, and where there's more likelihood that they may be they may have the opportunity for being eligible for a death benefit. The newer blocks of business are of the more modern form of variable annuities that I mentioned earlier, that typically have living benefit riders and such.
And that was my next question, is on the products that you have, like enhanced death benefit riders and things like that. What becomes the amount that's escheated? Is it the, I mean, I've seen people talk about the cash value of the underlying assets, but with death benefit riders, you could have a conceivably higher death benefit.
I believe it is the death benefit.
The death benefit rider, or?
The death benefits payable under that contract, which may include a rider provision.
And then on just general business out there for life, do you folks have what are called closed blocks, where you're not selling that policy form anymore, and what percentage of your business is in closed blocks on your in-force business?
So I'll start this, and then I'm going to ask Frank to give some color. When we talk about the closed block at MetLife, generally we're talking about business that existed prior to demutualization. Some of that is the industrial policies that we've already talked about. Some of it are ordinary policies. Do you have some color?
Yeah, I think perhaps the commissioner was talking about closed block from the perspective of not being actively marketed, and yes, so the most blatant example of that would be the industrial block. So we haven't sold industrial insurance since 1964. So effectively, that's a closed block. If I think I'm reading your question correct.
Well, for other whole or term life products that aren't industrial,
Yes.
do you have blocks where the business is not being sold anymore? It's you moved on to new, more modern policy forms.
Yes. Yes.
So
we
you
do.
have those closed blocks?
Yes, we do.
Do you ever change the non-guaranteed elements in them after they're closed? Just to,
I'm not sure. I can't speak specifically to any particular block. I'm sorry. I don't think I'm prepared to answer that.
Okay, we're going to take a break. I know that the schedule originally contemplated we'd come back at 12:30. We went a little bit long. Let's come back at, I'm sorry, did I say 12:30? What time is it?
I hope not.
All right, yeah, we're a little bit long. We're supposed to come back at 1:30. Let's come back at 1:45, and so we'll resume at 1:45. Thank you.